Donald Trump's attorney, Joe Tacopina, who represents him in the New York case. Mr. Tacopina, welcome to Meet the Press.
Thanks, Chuck. Good morning.
Good morning. Let me start with a simple question. Why did your client, Mr. Trump, make that claim that turned out not to be true? Did he make it up?
No, he didn't make it up. He was reacting towards a lot of leaks coming out of the district attorney's office. There had been a leak, Chuck, that Monday, the day before that Tuesday, there was a law enforcement meeting, including Secret Service and NYPD, that was going to go through the logistics of the arraignment. And then there was, of course, a lot of rumors regarding the arraignment being the next day. So he just, I think he just assumed, based on those leaks, that what was going to happen.
Has anybody
so it wasn't about making it up, and certainly he doesn't want to be arrested.
Has anybody in the DA's office contacted you or told you about special arrangements? Did he have any of this knowledge through you? No,
not through us. I mean, we've been in touch with the district attorney's office regarding potential logistics of an arraignment, if it gets to that point. But certainly didn't come from us. It came from the leaks that we all read in the newspaper that Monday or the Friday preceding.
Mr. Trump has described Alvin Bragg this week as a Soros-backed animal, said he was doing the work of anarchists and the devil, called him a degenerate psychopath, and he called him a Soros racist in reverse, saying this is the Gestapo. As his lawyer, do you stand by those comments?
So, Chuck, as his lawyer, I want to dissect this case because it's a case that shouldn't be brought and wouldn't be brought up for anyone other than Donald Trump. Let's be clear about that. Does anyone actually think, left, right, or in the middle, that anyone else will be prosecuted for making a civil settlement in a hush money case with personal funds? Of course not. No one's ever been prosecuted for that. You know, the closest we've come is John Edwards back in the day, where a donor paid $900,000 for his mistress and the child to be, housed somewhere. That case was ultimately dismissed by Department of Justice after they couldn't get a conviction, and that was with a donor. The distinction here is so vast, and it's clear to anyone, whether if you're a supporter of Donald Trump or detract or don't like anything about Donald Trump, we should all be concerned as citizens in this country about the weaponization of a prosecutor's office, and that is what this is. And I swear to you, in my 32 years as both a prosecutor and a defense lawyer, I've never seen an abuse of discretion like this.
Well, you say that. We don't know what the charges are yet. We have no idea what the charges are, but I go back to, is it,
no,
would you advise a client?
Have an idea.
Would you advise a client to personally attack a prosecutor like this? I mean, it's dehumanizing, Mr. Tacopina.
You know, Chuck, I know. I'm not his social media consultant. I think that was an ill-advised post that one of his social media people put up, and he quickly took down when he realized the rhetoric and the photo that was attached to it. But that being
You're
said,
only referring to the baseball bat. He didn't take down the other rhetoric. Wait a minute. You're referring to the baseball bat thing, which of course was featured in the New York Post cover. New York Post thought it was a pretty rough hit, and there was a doubt. I mean, here's the thing: we went through January 6th, so it's not like a possibility that Trump's rhetoric creates violence. It's already happened once. Are you not concerned this could happen?
Well, I'm not accepting that proposition that his rhetoric created violence. I think violence was on the way that day. But I'm not here to discuss that, Chuck. I'm not going to defend or condemn anything regarding social media. That's not what I do. I don't have anything to do. I'm not a Trump PR person. I'm a litigator and a lawyer. And I'm talking about this case in Manhattan, which is a case that would not be brought for anyone other than Donald Trump. When we seek to use a prosecutor's office to politicize and weaponize a campaign, that's what's troubling to me. And if you look at the facts here, just look at the facts for a second. You have two crucial distinctions. One, this was personal funds. Can you imagine the amount of people that would be baying for Donald Trump's scalp had he used campaign funds to pay for what they would call a personal expense? They would be going ballistic, and they would have a right to be going ballistic because the standard, the law, Chuck, and this is really important, the law is this, that if you use personal funds and you're involved in a campaign, the bright line test is, would you have expended that money? Would you have made that payment irrespective of the candidacy, irrespective of the campaign? And the answer to that question is simply yes. This was a personal civil settlement that's done every day in New York City. This had nothing to do with campaign finance laws. And members of the SEC have come forth, Chuck, and said this.
Yeah. No. Look, you may have your day in court to make this case, but you keep saying it's personal funds. That is not what Michael Cohen pled guilty to. This was funds where he was repaid by the Trump organization. Trump signed the checks.
No,
one of them
incorrect.
that was there. So you call it
Incorrect.
personal funds. It is in a court of law. It's been proven that it was Trump organization funds.
It's personal funds. It was not funds related to the campaign. That's the distinction.
But he used a Trump organization
it's
check.
Not campaign finance laws. But Chuck, that's personal. That's personal. It has nothing to do with
So everything with the Trump organization is Donald Trump's person? I mean, you realize the door you're opening there.
Chuck, you're absolutely conflating issues, and they don't go together. They just don't. This is a case that is being investigated because allegedly Donald Trump had an obligation to notify the FEC, the Federal Election Committee. Mm-hmm. He did not. The FEC has come forth and said that. This has nothing to do with whether he paid it through his organization, through a corporation, or his personal funds. These were personal funds. By all accounts, these were personal funds, not campaign funds. It's personal campaign, whether it's Trump organization, Donald Trump, the person, Mar-a-Lago Corporation, whatever it is, they're personal and not campaign funds. And that's the key distinction here. If they were campaign funds, we'd be having a different discussion. We'd be talking about how he used campaign funds to pay personal expenses, and they'd be baying for an indictment, as I said earlier.
But again, what this investigation may end up being is about the essentially the falsifying business records, which, by the way, this prosecutor has brought over 60, this one and the previous one brought over 60 times over the last 4 years. This is not an unusual crime to charge somebody with in the Manhattan District Attorney's Office. We have over 60 instances.
Chuck,
here,
you couldn't be more wrong. You couldn't be more wrong when you make that statement. This, first of all, would be a case of first impression. Never in the history of this country has this been done before, and never in the Manhattan District Attorney's Office has someone been charged with a crime for falsifying business records to pay hush money, as they call it, or it's a confidential settlement in legal jargon, regarding a personal matter. Never in the history of the Manhattan District Attorney's Office. If there were a filing obligation, if he had taken a tax deduction, which he did not, that would be a crime. If he had used campaign funds, we'd have an argument here. This was a personal matter, but
he called it legal funds. They called it legal fees. They claimed it was to pay a legal retainer.
In fact, they were in. No, it didn't say legal retainer. It was legal fees that was invoiced by Michael Cohen, who arranged this on his own with his own money initially, took out a loan, literally, resolved this without the president knowing, came back and then sent a bill in for 4 times the amount. Over the course of a year, it was paid off as legal fees, as was the invoice. Right. But what would he supposed to put in his personal ledger? Seriously, what would he put in his personal ledger? Payment for hush money to quiet an affair that I claim I never had, so my family doesn't get embarrassed. Is that what he should put in his ledger? There's nothing wrong with whatever you want in your ledger.
You keep saying what should be in the ledger?
Chuck.
Should it be the truth?
Chuck. Would you ever put a 4-paragraph sentence into a ledger? Chuck, you're being, honestly, I think you're being a little petty when you're looking at this now, because there is no filing obligation. You can put whatever you want in your own personal ledger. If there were a tax obligation, that would be one thing. If he had taken campaign funds, that would be something else. Neither of these things happened here. So you have a situation where you're looking at either, was it a tax deduction? They pulled it out of the grand jury because they thought initially he was taking a deduction. He did not. And secondly, did he use campaign funds? If he did not, he used personal funds. And the test, again, is would he have made that payment regardless of the campaign? And the answer to that question is a resounding yes, by all accounts.
All right. I do want to get you to respond to somebody who had a different point of view on this. And it was you a few years ago. Let me play this sound and get you to respond.
Quite frankly, Michael Cohen, again, has made statements that would give rise to suspicion for any prosecutor to say, that doesn't make sense, that a lawyer took out a home equity loan with his own money, paid somebody that he didn't even know on behalf of a client who, by the way, had the wherewithal and the money to afford $130,000. And by the way, didn't tell the client about the settlement agreement. It's an illegal agreement. It's a fraud, if that's in fact the case.
And we put in the if in fact that's the case, and I understand.
Did you hear that last line, Chuck?
I understand. No.
Did you hear that last line?
I understand that. So what is it that you've learned about this case that changes your point of view?
The facts. That what I just said, I'll repeat it again. that this was personal expenditure, not campaign money. The hypothetical question posed to me 5 years ago before I knew any facts, as a legal expert, as so many legal experts go on TV and discuss things they don't know, is I was asked a hypothetical question. I responded with this twice, and I'm reading the transcript. If that is in fact the case, I started with it, although I didn't hear it in your clip, but you did play at the end where I ended with it, which is, if that is in fact the case. So when I'm answering a hypothetical question without knowing the facts, but I'm responding to that hypothetical question, I will respond how I think appropriate. Now, what I since learned is that there were no campaign funds used, that there was an illegal invoice sent by a lawyer over the course of a year to cover these payments and more importantly, that the campaign finance law is clear. Bradley Smith, the former chairman of the FEC, has come on and said clearly that there's no campaign finance law involved here because he used personal funds and the expenditure would have been made irrespective of the campaign. Those are facts I didn't have before me 5 years ago as a hypothetical question was posed to a legal expert on TV.
All right. It sounds like you have a defense ready to go, but everything you've described, is probable. I mean, if you're a prosecutor, you're making these claims. Great. Show us your proof of it. It seems like there's enough at dispute here that actually this belongs in a court of law to resolve this.
Of course it doesn't belong in a court of law, Chuck. Listen, again, you can't bring a case, cobble two misdemeanors together to try and make a felony to meet the statute of limitations when not one misdemeanor exists. There is no crime here. There's not even a bad act, okay? Again, detractor of Donald Trump or not,
there's a crime here. I mean, the crime is the one that Michael Cohen, there is a campaign finance crime that he has pled guilty to that
Chuck,
involves the former president. So there's a crime at the core of this issue.
Wrong.
Well, but that's not what the federal government says.
If you listen
Michael
to
Cohen served time.
You're wrong.
What did he serve time for?
I'll tell you why you're wrong. Can I tell you a million different crimes? I mean, the guy was committing taxi medallion frauds, other perjury. Listen, if you want to just say it, fine. But if you let me answer, which is when Michael Cohen pled guilty, he said something that was so crucial to campaign finance law, and it's what every expert has used. Even if you accept the word of a convicted perjurer, liar, a guy who's lied in every form he's ever been in, he said when he pled guilty that this was done for the benefit of the campaign and for personal embarrassment to the client and his family, including his young son, Barron. Once he said the end part, it takes it out of campaign finance law. It's personal funds. Right. It had to be used exclusively for the campaign. It's like me buying a suit to go on the campaign so I could look better than if I had a old Reggie suit on. That's a personal expenditure. It's not a campaign expenditure. Even though it benefits the campaign, it's not a campaign expenditure. So when Michael Cohen said it was both for personal and campaign uses or reasons, that takes it out of exclusively campaign finance law, and there is no crime. I'm telling you, Chuck, that's the law on campaign finance.
We're going to find out. It is a very murky law on campaign finance, but it does, like I said, it sounds like
for sure
this is why you might need a court of law to figure this out. Mr. Tacopina, I really appreciate you coming on and sharing your perspective and obviously the perspective of the president in this case. Thank you, sir.
Thank you, Chuck.